Welcome back to Exhibit A List, where pop culture is chaotic, the law is messier, and somehow I make it all make sense. Grab your iced coffee, grab your sanity, grab your emotional support AirPods. The stories are storying this week, so let's get right into it. So, if your TV recently decided to take a 2-week vow of silence, don't panic. That was just Disney and YouTube fighting like divorced parents over who gets custody over ABC and ESPN because there was a big Disney versus YouTube TV streaming blackout from hell. We're talking millions of people staring at blank screens during college football. Is this the end of times? This all comes down to what's called a carriage dispute, which is basically corporate rent negotiations for airtime. Disney said, pay up. You're using our channels. YouTube said, relax. You're not the only princess in this kingdom. And Disney went, oh, watch this, and hit the blackout button. Ooh. And here's where the law slides in, wearing sunglasses and sipping a Diet Coke, and is like, there is no legal requirement for these companies to reach a deal. There is no law protecting you from your shows, from losing your shows, your games, your Good Morning America comfort segment. Is anyone still watching that? This is pure contract law. If the contract expires, the contract disappears. The FCC, they are not jumping in unless someone starts breaking antitrust laws or lighting fiber cables on fire. YouTube TV offered customers a $20 credit as the blackout dragged on. But that wasn't legal guilt. That was just like, please don't leave us. We can change. Streaming makes it feel like you bought access. But legally, you're renting vibes, and those vibes can be repossessed at any moment. Until Congress regulates streaming, expect more blackouts. Honestly, at this point, cable might sue streaming for emotional distress. And next, we gotta talk about Kim and Kris versus Ray J. That's the lawsuit that will not die, as many of our celeb lawsuits fail to do. All right. Let's talk about a story that has lived longer than low-rise jeans and refuses to retire. I'm talking about Kim Kardashian and Kris Jenner versus Ray J and this legal triangle of doom. We're in 2025 and somehow we are still litigating a tape from 2007. At this point, the tape deserves its own SAG card. So here's what's going on. Ray J has sued Kim and Kris for breach of a $6 million settlement agreement, claiming they violated a pact to stop referencing the tape. In response, Kim and Kris said, oh, cute, because you defamed us. And they filed their own lawsuit saying Ray J made false public statements, including claiming that they were under federal racketeering investigation, which, if untrue, is absolutely defamation territory. So let's talk breach of contract first. These we will never speak of this again agreements, they're absolutely real. Celebrities use them constantly to put scandals to bed, or at least a cryogenic freeze. But here's the problem. If either side breaks the promise even a little bit, the damages become very real dollars. So if Ray J is right and the Kardashians broke their no-mention deal, they might owe him some money. If the Kardashians are right and Ray J made false statements about crimes and federal investigations, that's defamation. That's lawsuit land. That's Exhibit A. Your bank account is now sad. Defamation is hard to prove. I say this every week, especially against public figures, which all three of them definitely are. Maybe Ray J a little less so, and this might be the way he stays in the public eye. But you need to prove that the statements were false and made with actual malice, which is not just, he said something mean. We're talking knowing it was false or reckless disregard for the truth, which, considering they have Hulu cameras rolling 24/7, might be easy or impossible, depending on whose editing bay you believe in. But here's the most celebrity law part of the whole thing. Both sides claim that the other is weaponizing the legal system for PR leverage. Ray J says the Kardashians sued to control the narrative. The Kardashians say Ray J sued for attention. And the court is sitting there like, ma'am, this is a Wendy's. The case is actually bigger than the tape. It's about who gets to tell the story in 2025 because the viral narrative is now just as valuable, sometimes more valuable than the legal one. And legally, you can reopen old wounds with new claims if there's a new breach or a new defamation. There's no statute of limitations on drama, clearly. So, can you really gag a Kardashian? Technically, yes, it's called a contract, but practically, absolutely not. Those women talk for a living. Okay, shifting gears from Hollywood scandals to Hollywood inheritance scandals, because nothing says family bonding like suing the people managing your father's legacy worth hundreds of millions of dollars. So let's talk about Paris Jackson versus the Michael Jackson estate executors. So Paris sued the estate, basically saying, hey, I think you're dipping too generously into the cookie jar. I mean, the multi-million dollar estate and paying yourselves and outside lawyers big bonuses without proper approval. This is the celebrity version of checking your bank account and being like, who spent $9,000 at Erewhon? Oh, right, me. Oops. But here, it's not that simple. Paris alleges mismanagement and breach of fiduciary duty, which are very real claims, if you can prove them. But the court said, I love that for you, sweetie, but where are the receipts? Judges need concrete evidence, numbers, documents, unauthorized payments, not just vibes and suspicions. And without that, almost all her claims were dismissed. And here's the painful part. The estate is now trying to make her pay their legal fees, which honestly is the court equivalent of someone eating your fries and then handing you the bill. Challenging an estate, especially a massive professionally managed celebrity estate, is incredibly hard. Courts tend to trust executors unless you come in with specific, undeniable proof of wrongdoing, which is hard sometimes. No proof, no case, though. And in trust and estates law, losing isn't just oops. It can mean you lose the lawsuit, you lose money, sometimes you end up paying someone else's attorneys, and it can be devastating. Millennials and Gen Z, listen up. Estate litigation is sexy in the headlines, but legally, it is slow, expensive, brutal. You can absolutely challenge executors, but you need evidence, not emotions. Courts don't care if you feel something's unfair. They care about bank records, accounting reports, misappropriation evidence, missing approvals, provable breaches of duty. I don't like how much they got paid. So what's the lesson here? Even celebrity estates run by seasoned professionals can get messy, but courts want facts, not family drama. And in this round, Paris didn't just lose. She might be picking up the estate's legal tab. Being an heir is cute until the invoices start arriving. All right, let's move from pop star estates to one of the most infamous legal sagas still echoing through American courtrooms. O.J. Simpson, the Goldman family, and a judgment that refused to die. So, huge update. O.J. Simpson's estate has agreed to pay the Goldman family nearly $58 million. Yes, million. Yes, even though the original civil judgment was issued in 1997. Yes, even though O.J. is dead. This is the legal version of surprise, babe, your karma package has been delivered. Quick refresher for the younger crowd. O.J. was acquitted in criminal court of murder. But in civil court, a jury found him liable for the wrongful death of Ron Goldman and awarded the Goldman family $33 million. Civil and criminal law play different roles. Criminal is held to the standard of beyond a reasonable doubt, but civil is a preponderance of evidence, basically like more likely than not. So he walked free criminally, but he owed millions civilly. But here's where the law becomes petty in the most satisfying way. That $33 million grew to almost $58 million because of decades of interest. Interest does not care about your feelings or your bankruptcy filings or your NFL pension or anything really. OJ spent years shielding assets, living in states with strong pension protections, and basically paying almost nothing toward the judgment. But death ends a lot of things, but not death. His estate went into probate, creditors filed claims, and the executors agreed the Goldmans are owed $57 million, $58 million. Precision matters. The law loves decimals. Here's how probate works in big cases like this. The IRS gets paid first, always. The IRS is the Beyonce of creditors. Then comes the judgment creditors, like the Goldmans, then other debts, then maybe family or beneficiaries. So OJ's heirs are not touching anything until the government and the Goldmans are paid. Will the family get the full $58 million? Maybe not. It depends on what the estate actually has. But for the first time in decades, they're actually in line to collect something meaningful, and that's huge. The legal takeaway for anyone listening is civil judgments cannot outlive you. You cannot outrun them. You cannot vibes your way out of them. And probate will absolutely track you down from the afterlife. The universe may move slow, but civil judgment interest moves fast. And for the Goldmans, after 30 years, the legal system finally said, here's the money. All right, let's jump into the courtroom energy surrounding Blake Lively and Justin Baldoni, because there is new news, and the news always comes with these two. Justin Baldoni has officially filed his motion for summary judgment, and that means he's asking the court to throw out Blake Lively's harassment and retaliation lawsuit before it ever reaches a jury. Summary judgment means you're saying there is no triable issue of fact. Even taking the evidence in the light most favorable to Blake, no reasonable jury can find in her favor. So it's saying there's nothing to see here. Let's all go home through legal filings without ever reaching trial. Now here's the twist. The actual motion is sealed. I couldn't get my hands on it for you guys. I don't get to read the receipts, but all we can do is legally and logically surmise what Baldoni's team is arguing. And based on 100 years of civil litigation patterns, here's what these motions usually say in cases like this. They usually would say the conduct Blake described doesn't amount to actionable harassment under the law, that there was no adverse employment actions tied to her allegations, that anything that did happen wasn't severe, pervasive, or connected to discrimination, that the evidence she submitted doesn't establish retaliation or damages, and that her claims are unsupported enough that a jury couldn't reasonably side with her. That typically is what a summary judgment playbook in a high-profile harassment suit would look like. Meanwhile, Baldoni's own massive $400 million countersuit for defamation was dead, gone, dismissed. So now he's trying to get the same done to her claims. So where does this leave Blake? Her case is still alive, but the judge can rule in Justin Baldoni's favor, and that would cut things off right here. Most likely she's going to file a counter motion for summary judgment and ask for the same relief, that judgment be entered in her favor and that no trial is necessary. Or if she presents any evidence that suggests a triable issue, even if it's a small one, the judge will have to typically let. Here's the legal reality. Summary judgment is hard to win with harassment cases because so much hinges on credibility, intent, and context. Things juries usually decide, not judges. So if Blake presents any evidence that suggests a triable issue, even a thin one, the judge typically has to let it proceed. But if the judge thinks her evidence is too vague, too limited, too disconnected from actual legal standards, the case can get tossed before it even goes to trial. And that's the moment we're in right now. We're in that wait and see period. And by the way, the trial is scheduled for March 2026, which sounds far away, but in litigation world, that's basically tomorrow. Big entertainment cases move at the speed of continental drift. So if the summary judgment motion fails, this will be a very public trial. If it succeeds, this entire lawsuit ends quietly, except for the part where it explodes all over the internet anyway. Bottom line, Baldoni wants it out. Blake wants her day in court, and the judge is currently given the task of deciding whether this becomes the Hollywood trial of 2026 or just another sealed PDF that changed nothing but maybe raised my blood pressure. All right, now we're stepping out of Hollywood and into the medical legal world, but don't worry, the drama is still very much drumming its fingers on the table. Let's talk about Hulk Hogan's family and why they just filed some paperwork hinting at a potential medical malpractice lawsuit connected to his death. So here's the latest update. Hogan passed away earlier this year, but his family believes something may have gone wrong months before that, specifically during a neck surgery in May. The lawyers filed a petition asking the court for a 90-day extension of the statute of limitations. What does that all mean? They're saying we need more time to investigate before we decide if we're officially suing. That's a pretty common move when a family thinks something medically questionable happened but hasn't gathered enough evidence yet. To be super clear, they have not filed a malpractice lawsuit. Not yet. Right now, they are in what I call, is this real or is this grief phase of litigation, where families investigate whether there was an actual breach of care or just an unfortunate health complications. In their filing, Hogan's wife and son claim a surgeon may have damaged his phrenic nerve during the neck operation. That nerve controls your diaphragm, your breathing, and if it's injured, you can have chronic shortness of breath and long-term respiratory issues. Hogan reportedly did experience breathing problems afterward. So the family is basically asking, did this contribute to the heart attack that ultimately killed him? Here's the legal nuance. In medical malpractice, you need two things. You need negligence, that someone deviated from accepted medical standards, and causation, that mistake actually caused the injury or death. Causation is always the harder part, especially when you're dealing with older patients, multiple health conditions, and events separated by months. It's not enough to say he had complications. You have to prove the medical team did something wrong and that mistake was a significant factor in what happened. Also, malpractice deadlines are brutal. You snooze, you literally lose. You miss the deadline by a day, your case is dismissed. End of story. That's why families often file these extension petitions quickly, even when they're not sure yet if they're filing a full lawsuit. It locks in their right to explore the facts. Stay tuned. This could become a full-blown malpractice lawsuit, or it could quietly end with no wrongdoing found. But either way, it's a reminder that medicine, and especially in malpractice law, the clock is ticking and the minutes sometimes. Okay, let's lighten things up with a story involving absolutely no sex tapes, no malpractice dramas, and no streaming blackouts. Just two massive corporations fighting over Jeopardy and Wheel of Fortune. Like they're the last pack and play at a Bye Bye Baby. CBS and Sony have officially ended their high-stakes legal spat over who gets to distribute America's favorite game shows, the ones your grandparents still watch live, full volume like it's the Super Bowl. The dispute was about syndication rights, which is legal speak for who gets paid every time Pat Sajak spins the wheel or someone forgets to phrase their answer as a question. Here's the outcome in plain English. Nobody won and nobody lost. They negotiated a very structured breakout. This settlement basically says CBS keeps distributing Jeopardy and Wheel of Fortune in the U.S. through the 2027-2028 season. Sony takes over the international distribution next year, December 2025. And the wildest part, CBS gets to keep U.S. advertising sales through the end of the 2029-2030 season. Because who cares about love when you can have the commercial spot revenue? This truce comes after Sony accused CBS of making unauthorized streaming and licensing deals and allegedly fudging the advertising revenue. CBS clapped back. So even wholesome game shows hide some very unwholesome contract litigation. This was not just about where the episodes air. It was about millions in ad deals, digital rights, and long-term streaming revenue. The funny part, viewers won't see a single difference. Jeopardy will still air at the exact same time on the exact same channel. Your stepdad refuses to DVR because he likes to watch it live. This entire bloodbath happened so the rest of us can keep guessing trivia questions wrong in peace. Call it what it is, a corporate divorce where both parents agreed to stay together for the kids, but secretly they rewrote the prenup. All right. Now let's get into the topic that divides families, ruins brunches, and makes everyone panic when they open their Venmo. Because we need to talk about tipping. What's legal? What's optional? And what's just America being America? Here's the headline. There is no federal or state law in the U.S. that requires you to tip. None. Zero. You cannot be arrested, fined, sued, subpoenaed, or dragged to small claims court for not leaving 20%. But are you comfortable ever trying to pull that at the nail salon? Legally, though, a tip is voluntary. Now, socially, if you stiff your server, may God help you, because the side eye will be criminal. But legally, you can walk out of a sit-down restaurant having paid exactly the bill total and nothing more. You're not violating anything except the social contract and maybe your reputation. However, let's talk about one big exception: automatic gratuity. If a restaurant adds a 20% service charge or 18% gratuity for parties of 6 plus, that is not actually a tip. That is a service charge. And service charges are legally enforceable. So you got to pay those. Why? Because once it's on the menu or receipt and you choose to receive the service, it becomes part of the actual contract between you and the business. So refusing to pay that, that's a different story. You are now refusing to pay the full contract price, which can become a legal issue. Most restaurants now label these as service charges on purpose. It protects them. And in some states, it has tax implications. Fantastic. Nothing like dining out to feel like you're filing a 1099. But let's talk about when you do not have to tip, legally or socially. Fast food and counter services like Starbucks, Chipotle, the iPad swivel screen of shame asking you to tip between 15, 18, 22, or even 700%. You do not have to tip. Half the world doesn't. The other half actually does, because they just don't want their barista to think they're mean. Either way, it's optional though. Now, how about basic assistance? A doorman opening the door, a hotel employee pointing you toward the elevator, someone handing you a cup of water. No tip is required, legally or even socially or spiritually. But why does tipping exist at all? The real problem is that American wage law allows restaurants to pay servers a tipped minimum wage, often as low as $2 to $5 an hour, with the assumption that tips will make up the difference. So tipping isn't legally required, but tipping is baked into the wage system, which is why it feels forced, even though the law says it isn't. Basically, we built a whole economic structure on guilt. If you're thinking that's insane, yeah, well, welcome to the American labor law. So the big legal question is, can a restaurant force you to tip? The short answer is no. They can add a service charge, but they cannot make you voluntarily tip. They can refuse service, though, if you're a habitual non-tipper. They cannot detain you, they can't call the cops, or add an unsolicited tip after the fact. That would be fraud. So just to break it down, tips are voluntary. Service charges are legally enforceable. Not tipping isn't a crime, it's a personality test. Customer service, you owe nothing. Door holding, please stop tipping for oxygen. Servers rely on tips, though, because the law allows it. And it's not because society should. It's because that's how the wage laws have been structured. Tipping culture isn't law, it's social contract. And I'm not saying you shouldn't tip. I just wanted you guys to kind of understand that it's not a legal thing, it's a social contract thing. We still have to do it because we don't want to be horrible people, but let's be clear on what we have to do. It's mostly the fear of being judged, but your server may judge you, your date may judge you, your friends will definitely judge you, but the law just doesn't care. All right, babes. That's it for this week's docket on Exhibit A-List, where the pop culture is extra, the law is messy, and your girl is here every week making it all make sense so you don't have to Google anything at 2 a.m. We covered corporate tantrums, celebrity lawsuits, generational estates, malpractice mysteries, game show custody battles, and the legal illusion that tipping culture is tipping culture. And somehow it all fit into one episode, so that's talent. If you loved hanging out today and you love what we're doing over here, make sure you're following the pod. Make sure you're following me. Leave me a review. Share this with your group chat, your mom, your lawyer friend, your ex, whoever needs legal clarity with a side of spice. And don't forget to tag me on socials. I'm on Instagram at JasmineWegESQ and Exhibit A-List Pod. TikTok at Jazz the Lawyer. I love seeing where you're listening from. Bonus points if you're blasting this in your kitchen pretending you're in a Bravo confessional. All right, court is adjourned for the week. Go be hot, go be smart, go know your legal rights, and I'll see you on the next Exhibit A list.